Dialogue.
Igbo Area TV, on the Igbo.
Hello viewers, how are you doing? Judgment debt. Innoson seeks court order restraining GTB from name change. You know, GTB has applied to change name, and Innoson knows what this will lead to. So IVM, Innoson Vehicle Manufacturing, Innoson Group of Companies, through one of its subsidiaries, Innoson Nigeria Limited, has asked the court to stop Guaranteed Trust Bank, GTB, from transmuting to a private and financial holding company until it pays the over 32 billion Naira Supreme Court judgment debt. You know, this debt it has become 32 billion as a result of accumulation. Innoson borrowed money from the bank at certain interest rates, and the bank, while deducting, continued to deduct after Innoson would have paid all the money, still at the same rate. Now they went to court. The court asked the bank to pay Innoson back the money still at same rate, which is the normal thing, but the bank wouldn't. It was about 4 billion Naira then. Now it is 32 billion Naira. So, a statement by Colonel Osigwe, spokesman Innoson Motors, alleged that GTB was attempting to change its name in order to evade the payment of the 32 billion Naira court judgment. Osigwe emphasized that as Innoson was awaiting GTB to come up with a payment plan for its over 32 billion Naira judgment debt, the bank resorted to a scheme of deregistering itself as a public limited liability company and re-registering as a private limited liability company and a financial holding. It be like say this one, oh, wayo. Something is something fishy, and Innoson had to quickly raise alarm before if this hand where they put for soup it cannot turn to monkey hand. Osigwe stated that the Supreme Court of Nigeria had struck out GTB's motion filed to set aside its earlier decision order that was made on February 27, 2019, dismissing the bank's Court of Appeal judgment of February 6, 2014, which was in favor of Innoson Nigeria Limited. He recalled that the Federal High Court, Oka Division, on March 27, 2019, pursuant to Supreme Court dismissing GTB's appeal, granted leave to Innoson to enforce and execute the judgment garnishi order absolute made by the court Quorum Shakaho J at Ibadan Judicial Division on May 18, 2010 and July 29, 2011 respectively. As you can see, you can see when this started, and look at what it is now as a result of accumulation, as a result of stubbornness, refusing to obey court orders. This order was concurrently affirmed by the Court of Appeal in the judgment of February 6, 2014, and by the Supreme Court in its judgment of February 27, 2019. Osigwe stated that as Innoson commenced the act of court execution, the bank returned to the court via its motion on notice seeking orders, staying of suspending the execution and backed by Innoson, and also sought orders setting aside the ex parte orders made by the courts, granting the automobile company leave to enforce the judgment, he added, while refusing GTB's application and staying further proceedings. The court further held the order it made on March 27, 2019 in favor still of Innoson Nigeria Limited, granting it leave to enforce the judgment and issue processes of execution of the judgments are valid. Also, that all the steps taken to levy executions in pursuance of that order are still valid and are not vacated, while all the prayers by GTB in its motion of 1st April 2019 are not granted. GTB, however, rushed back to the Supreme Court and applied for an order setting aside the Supreme Court's judgment, dismissing its appeal against the above judgment. However, the Supreme Court struck out the motion on Thursday, November 3rd, 2020. He said the auto company had sued the bank at the Federal High Court and therein sought court restraining the fourth defendant, Corporate Affairs Commission, from registering the first defendant, GTB, as a public limited liability company, and or registering the first defendant, GTB, as a private limited liability until GTB pays the outstanding judgment arising from that particular suit. That was 2012. It also asks the court to stop Corporate Affairs Commission, that's CAC, from registering or re-registering the GTB as a holding or financial holding company, whether as a public or private limited liability company, until it pays Innoson Nigeria Limited the outstanding total judgment debt of 32.8 billion naira, arising from that same suit of 2012. And besides, Innoson also sought an order cancelling GTB's special resolution and or any order of its resolution that it should be deregistered as a public limited liability company or be re-registered as a private limited liability company and or holding company until it pays the sum arising from those suits. The statement added, an order setting aside the third defendant's Security and Exchange Commission, no objection to first defendant's proposal to be registered as a private limited liability company and as a holding or a holding financial company. An order setting aside the second defendant approval in principle granted to the first defendant to operate as a holding financial company. For those of us who are not familiar with this suit, this GTB versus Innoson case, we have videos for this on this channel. It's packed, and we will put the link so that you will access the videos. You will know how it started, how it got to this. Yeah, we'll put a link of those videos so that you will connect and you understand how it came to this. The judgment debt came to 32.8 billion. Meanwhile, please subscribe to our channel, click on the bell icon to get our updates, share this video widely, let it circulate.
Thanks for watching Igbo Area TV. Please subscribe to our YouTube channel. Also click the bell icon, like our Facebook page, join our Facebook group, follow us on Twitter and Instagram. Bye for now.